Ed? You're up for our next two? Thank you, Cassandra. Thanks, Michelle.
Okay.
We don't know
So,
who you are, so we really need that name tag. It's
next item.
Brian.
Thank you. So, yeah, this is actually starting a process that you're going to be hearing about over the next several months. It's another regulatory process that we're initiating. In this one, it has to do with trying to define what's credible compensation. And before I do that, I just want to sort of preface that you're going to start seeing more regulatory issues coming before the board. Historically we did very few regulations. We did some a few years ago around elections because we needed to. We did penalties and interest. That was a fairly lengthy process, fairly substantial process. Then we did one on the appeals process. And now we're going to start one with credible compensation. But I just wanted to give you a heads up that at the November Legislative Committee meeting, in addition to presenting any legislation that we are proposing the board sponsor, we're also going to be presenting proposed regulatory changes. And so, we're going to start utilizing the regulatory process more and more. So this is sort of the first step on this particular one, and I just want to provide you just a little background about what we're doing and why we're doing it, and then trying to getting some direction from the board, hopefully that we would proceed along those lines. In the defined benefit program, the benefits that are provided to members is based on three factors. One is the age of the member when they retire. It's a percentage of for every year of service of their final compensation. The second one is their service credit that they accrue while they're working. And then finally, it's their final compensation, and that dictates the benefit that they get every month. What's significant is that the credible compensation actually drives two of those three factors. With respect to the service credit, their service credit is how much credible compensation they actually earn as a percentage of how much they would earn if they worked in that position on a full-time basis. And then their final compensation is what their full-time credible compensation would be, either on a 3-year average or a 12-month basis. So what is credible and what's not credible becomes extremely important in determining a member's benefit, and that's what this regulatory process is going to better define what is credible and what's not. Historically, what was credible was somewhat limited. Back in 2000, the board sponsored legislation, Assembly Bill 2700, which took effect in 2002, that expanded what was credible compensation. It was really more to reflect the fact that the world of education was changing in terms of how people got paid and the kind of work they performed. Historically, things such as summer school was specifically not creditable. Any work that members did in excess of their full-time contract was not creditable. So if they taught, if they were a coach, for example, and they were on a full-time contract, that coaching would not have counted towards a retirement. Any number of things didn't count. Paper performance didn't count. Bonuses didn't count. And so, but over half of our members, for example, teach or perform some service in excess of a full year service credit. And so the board sponsored legislation to try to in order to expand what was credible, in order to reflect the way that the profession had changed over time. Other things would not be credible, and we'll talk about that in a second. So credible compensation is the compensation that's paid for performing creditable service. And what is creditable in the Education Code is defined as 10 very specific activities, such as being a teacher or an instructor, counseling, being a program director, a librarian, a nurse, preparing instructional materials, being a superintendent. There's some very specific activities that if you get paid for performing that activity, that's credible compensation. Now, the kind of thing that counts as credible compensation is compensation that's paid to the member in cash to everybody who's in that same class of employees. And what we mean by a class of employees is people who are in a group because they are employed to perform similar duties, are employed in the same type of program, or have other similarities that are related to the work that they perform. So, for example, all teachers are going to be in a class of employees, or all nurses are in a class of employees. And so as long as everybody can have that compensation paid to them for performing that credible service, then that compensation would be credible and would count towards their retirement. So what that leaves is that there is some compensation that's not creditable, that is specified in the law, and then there's other compensation that is creditable, and depending upon the nature of that compensation, it either gets credited to their DB program, so it counts towards their monthly benefit, or it gets credited to the DBS account, which means that when they retire, they'll get a benefit based on the contributions that are paid on that credible compensation. The type of compensation that's not creditable at all to CalSTRS are things such as fringe benefits, reimbursements for a job-related expense, certain expenses, certain costs that are incurred, paid directly by the employer to a third party, those kind of where the member never actually sees the money, those kinds of things are not creditable. What is credible to DB are going to be cash compensation that's payable to everybody in the class of employees that's for the service that's less than that full year service credit. For the kinds of things that are credible to DBS and not credible to DB and does not count towards your final compensation is the compensation is paid for service in excess of a full year service credit. So if, for example, you have a full-time teacher who teaches summer school, is a coach, does something, some extracurricular activity, then that additional compensation does not count towards their final compensation. Instead, that compensation, those contributions go to the DBS account. In addition, as a means by which the CalSTRS plan controls spiking, if the CalSTRS makes a determination that compensation is being paid for the principal purpose of enhancing a member's DB benefit, then that compensation does not count towards DB. Instead, those contributions go to DBS. So the way that the plan is structured is intended to provide recognition for retirement benefit purposes of pretty much whatever the member earns for performing credible service, but does it in such a way to try to control the extent to which spiking can occur. So when AB 27 was enacted and took effect, we had to provide a lot of guidance to employers because things were going to be a lot different than the way they used to be in terms of what they report to us as compensation, because things that were that didn't used to be reported would now be reported, and depending upon the nature of the compensation, they have to report in a particular way. CalSTRS, in an effort to try to provide some assistance to the employers, developed what we called the Credible Compensation Guide. It was a very detailed, very lengthy document that provided a lot of guidance in terms of how things get reported, what assignment codes they should use, giving a lot of examples and a whole lot of assistance along those lines, and at the same time provided some directives, provide some additional guidance. But unfortunately, none of that, because they didn't go through the regulatory process that were binding legally. So we provided all that guidance. It was on our website, but then we made a determination that it really wasn't appropriate to provide that without going through regulatory process. So we pulled the guide specifically from the website. But the internet being the internet, it was out there and people downloaded it and they put it on their own websites and continued to use it as a basis upon which they made reporting decisions. And so what's happened over time is that there's a fair amount of inconsistency at the field level in terms of what gets reported to us and how, and we end up creating a lot of ambiguity about what's credible and not. Part of the issue is that in the statute, for example, it says fringe benefits are not credible, but fringe benefits isn't defined anywhere. There's a variety of terms that are used, but there's no definition for it. And so what we're trying to do in this particular situation is try to provide some guidance that is in fact legally binding. The employers have been very clear that over the last several years that they're a little bit unclear in their own minds, given the fact that we don't have any official guidance to them about how they're supposed to report certain compensation, such as things like additional assignments. How do they define a class of employees? What about allowances? Are allowances credible or not credible? So the purpose of this effort is to do a variety of things. One is to provide, as best as we can, absolute clarity about what the law says, provide some consistency so everybody does it the same way as best they can, and that's something that we can actually enforce in law, as opposed to simply saying, well, this is the way we've always done it, and then we are more subject to issues around what administrative law judges do if a member should appeal it. So that is something that when we've had that conversation with the employers, with our stakeholder groups, they've all said that really what they want to do is just tell us what's credible and what's not credible. We'll make it work. We just need to have some clarity about what that is. And so that's what the purpose of this regulatory effort is, to provide that absolute clarity about what is and isn't credible, so that everybody's sort of operating from the same page. So in terms of the process, assuming that you direct us to go forward with it, that we will be doing is having the board will have an initial reading of the draft regulations, as well as a request for authority to undertake the regulatory process at the November meeting. Assuming that we do that, they will issue a notice of proposed rulemaking to initiate that process on a more formal basis. There'll be a 45-day comment period that begins when the Office of Administrative Law publishes the notice, which is generally on Fridays. So it'll be sometime around the end of November that we'll do that. The 45 days would end sometime in early January, and then there would have to be a public hearing immediately thereafter. And one of the decisions that you'll need to make is whether or not you want to delegate the authority to conduct that hearing to Jack, or whether you want to conduct the hearing yourself. That's your decision. We can provide you some guidance in November about the pros and cons of different approaches.
Tom wants to
And we've
conduct
done
the
both.
hearing. Tom
You've
wants to
done
conduct
both.
the hearing.
You have done both. And I think the last time we conducted a hearing, and literally nobody came.
No one came.
That's
Yes.
okay. So that's entirely
One
your
person
call.
came, maybe.
And then as a result of the public hearing, we can do some draft responses to comments that are received during the 45-day comment period, update the draft. There could be a second reading if there's no second comment period needed, we can complete the process in April, and then it's a fairly aggressive timeline, but we would like to try to have the regulatory changes become effective July 1, 2004. What we will be doing in an effort to try to minimize or to maintain that aggressive timeline, just like we did with the penalties and interest regulations, is that we'll work very closely, assuming that you direct us to go forward with it, working with the stakeholders, working with the employers to share with them the drafts, so that we can iron out whatever issues we can possibly iron out around the draft regulations, so that what you see will, to the best extent possible in November, reflect a consensus understanding of how the regulations will work. And obviously, people have an opportunity to discuss it at November, and we can do some further refinements. But we think that we can make it within that time frame. We've had a number of conversations with the employers already to try to identify the issues that they've had with reporting. We started some conversations with some of our member organizations to identify their issues. And quite honestly, as I said, the biggest issue is just tell us what the rules are. You know, they're in some respects they're not always as concerned about what the rule actually is. Just tell us what they are. So we hope to be able to do this entire process in that time frame. So with that, I'd be happy to answer any questions and hopefully get your concurrence that you would direct us to proceed with that process.
I can't hold it in my brain now. I'm trying to remember what my question was. I guess I just wanted clarity on, so you're saying the teacher's retirement law does kind of talk about credible compensation and talks about these 10
activities.
10 activities. And so what you're saying is that what we're pursuing is something that's clarifying to that law?
Yes.
Is
Yeah.
that, so that's what we're doing?
yes,
is we're providing a little more definition, so in the areas that are kind of vague, like the fringe benefits,
Correct.
that will provide more specificity so that districts can better determine what is creditable and what is not credible compensation.
Yeah,
correct?
that's an example. Other things
Okay.
like how do you determine a class of employees? What causes something to be credible versus not credible, or causes it to be credible at DVS? There's a variety of things within the definition of
Right.
credible compensation that we need to clarify.
Well, I know that we've talked about this a lot, about community college, part-time faculty, and I know creditable compensation has been a huge issue. It's a huge need for us to get more clarity, and honestly, anything we can do to help districts give them tools to be clear on how to report data back
Yes.
to us, I highly, highly support. So I just
Good.
want to give my encouragement and support to move this along and all the, because I think it's something that, our educators in California need our support for districts to have accurate information, so.
Good. And just so you know, that the focus of the regulations is going to be more on the 2% of 60 members rather than the 2% of 62 members. We may, I think as discussions, there's a variety of things that are being clarified in the law this week around 2% of 62, but we may need some additional regulations, but that will be farther down the road.
And so Ed, on the off chance we happen to just miss something as we do our regulations, they go through, they're adopted, they go through the Office of Administrative Law, it gets printed up, they're effective. And then we discover that, wow, we missed something.
Right.
How easy is that to go back and slip something back into the regs?
I wouldn't
don't we
use
have
the
to do
word
this
slip.
again?
Oh, please, do
How
not,
easy is a
do
regulation
not
to
mention
amend?
that to him.
Your lawyer didn't
See,
hear that.
Brian squirms when I use the word slip. So.
Yes, very much.
We would have
We
to go
didn't
through
attach the word fall
The
to it
lawyers
this
It
heard
time.
that.
depends
Okay.
upon the materiality of the change.
Yeah.
So there are some that you can do as sort of a ministerial, just, making edits and corrections is a very easy process, but if it's material, then you have to go through a notice and comment period.
Is that shorter than the time period that it is for the initial?
The initial, yes.
promulgation? Okay.
Well, and sometimes we may find in the course of after the public hearing that we make substantive changes before we even adopt the regulations.
Yes.
That would require another comment period.
Another
So-
comment.
Right, no, I
Yeah,
understand that.
yeah.
That's like where we come up with the second. And
Right, but we can always do additional regulatory
Okay.
changes. I mean, I think you will be seeing regulations on a more regular basis than you have in the past.
Yeah, I think so too. All righty, Michael?
I think I would suggest that we kind of combine this with the precedent structure that we're putting together with the appeals process. There will be circumstances, factual circumstances, that will require some interpretation, that won't necessarily rise to the level of amending the regulation.
Right.
So, if you have multiple appeals coming up with the same question, you might then say, let's go ahead and amend the regulation because we've decided that this is how we want to interpret this particular section. But I think the extra tool in our toolbox of issuing precedential rulings at the appeal level may eliminate the need to go back through
Yes.
this process again and again.
Cool.
And that is the two-pronged process that has come out of the compensation review unit and input on this. So that is our plan.
All righty, super. See no one else? I see Jennifer at the mic. Hi, Jen.
Good afternoon, Jennifer Baker with the California Teachers Association, and I know of course, the management did go to the other side of the room, but I did want to mention. He didn't want to stand with me, but I did want to say on behalf of the California Teachers Association that we really appreciated the process that you've started when it comes to creating regulations, because I know that this was something that CalSTRS was not always involved in the past, and we have to really commend both you and the direction and guidance that you've given to staff through the previous processes that we've done with regulations. One of the primary reasons it's gone so well is because you've been very transparent and staff has been very transparent, and we've been able to work things out. It's likely if there are going to be any bumps in the road, it might be between both ourselves and perhaps AXA, where we could have some colorful conversations that we can hopefully work out. But I think that the process is going to be very positive, and I actually think we're going to yield good results for everyone. So we just wanted to say that we're appreciative of the work that we're about to do together.
Thanks, Jennifer. Hey, Sal.
Salvia Senor with the Association California School Administrators. I just want to echo what Jennifer mentioned, but also emphasize what Ed spoke to. One of the biggest concerns or complaints that I get at the state level for this association is that in the field there's an issue with clarity. And it's about just tell us what exactly is it that in your eyes is credible. And I think we've seen a challenge with this as we've seen larger numbers of retirements that have taken place over the last 12 to 16 months or 18 months. And so I think this is going to be a very, very helpful process for school districts, and in particular, those employees that are preparing for retirement to know that, or better yet, those that are far away from retirement, knowing what it is that, in fact, at the point of retirement, is going to be considered credible. So,
Exactly.
again, thank you very much, and we look forward to working with you.
Thank you, Seth. Ed, you want to have anything to?
No, just want to make sure that you want us to go forth and do good things.
Well, seeing that it's an informational item, I'm not so sure we can vote on it.
They
But,
can direct us.
but
Directing is not
after
an
hearing
action.
our two
You have our
constituency
blessing.
groups, I think you might want to come back in November.
That's right. We'll slip something through.
You're gonna give Brian
And then,
some more
and then
gray
legal
hair,
will
Ed.
fix it.
Thanks, Ed. Go ahead and go on
Sure.
with the buyout.
Yeah, so this is really a follow-up to an earlier discussion we had with the board back in February, where there's been certainly some media attention around what we would refer to as pension buyouts, where they'll be solicited by companies who will offer to provide a lump sum of money to a person in return for receiving the monthly benefits that get paid either as a pension, primarily at the military level, but in theory, it could occur to our members as well. And the board asked us to come back and sort of identify, what could we do to try to address that. So we wanted to provide some follow-up with some possible alternative actions that we take it and sort of our own sort of evaluation of which ones would work well and which ones would pose an issue. One of the things that I need to make sure that people understand is that our law is quite clear that you cannot assign a benefit, a CalSTRS benefit, except in very specific situations, such as child support or withholding of taxes or something along those lines. Is that basically our interpretation of our existing law is such that a pension buyout arrangement would not be legal. So it's not clear, as we talk about later on, that actually amending the law or doing regulations would necessarily add anything to it, because it seems to be as clear as it can be. The other thing is, just so that you know, that some of the things that we've done since the February meeting is that we actually published an article in our Retired Educator about pension buyouts and about the restrictions that exist and the substantial downsides of these arrangements, because effectively what you're doing is borrowing money against your own pension, and you're going to pay really quite exorbitant interest rates, although they aren't technically considered loans, but they are effectively loans, and they'd be paying interest rates 25-30% annual interest rates. And so it's a very, very expensive way of trying to get some money up front. The thing that was unfortunate is sort of the no good deed goes unpunished, is that what we found after we published the article is that we actually heard from a number of people who wanted to find out more about it because they were interested in doing it. So, that was sort of in a period of time where I think people were still having
like the reverse
substantial
mortgage.
economic problems. Hopefully, that's not quite as severe as it was back then, but it's something that we just need to be aware of, is that in some circumstances we provide too much, visibility of this opportunity. Some people who want to take advantage of it. So, in any case, there are a variety of things that we've identified in the item that may or may not be effective in terms of trying to address the issue. There, we have gotten some interest from the U.S. Congress, and we've been working with them. They haven't really done anything at this point, but we'll continue to keep in contact with them, the sort of the things that they want to do. We also worked with some of the national associations on pensions and retirement security to get a sense of how big a problem this has been in other pensions. And what we found is, most of the pensions like us have statutes that don't allow assignment of their benefits, and none of them have identified any sort of trend that it indicates that this is becoming a big issue. But in terms of the things that we can do, that we've identified as possibly doing is doing things, for example, examining the companies that offer pension buyout arrangements and on the chance that attention might dissuade them from working with CalSTRS members. We don't have any explicit authority to do that. We could perhaps work with other state agencies that perhaps have some authority around those lines. We've also had made contact with the state attorney general around this issue. They haven't seemed to move forward on anything, but we could work with other entities to try to examine these companies to see, to try to perhaps, as I said, dissuade them from trying to work with our members. The second option, as I said, would be some additional regulation or legislation. Quite honestly, our laws, it seems clear enough. We've talked with outside counsel. They think it's clear enough. In our view, amending the law isn't going to make it any clearer. It's just a question of just enforcing the law, assuming it's a problem. I do want to say, by the way, that we don't have any sense that this is a problem for our members. When we just completed our biennial retirement readiness assessment, where we survey our members to get a sense of how ready they are to retire and how their retirement experience has been. And of the people who have already retired, who we asked them the specific question, are you participating in a pension buyout, and explaining what that meant, literally none of them said that they were participating in any such arrangement. So either they don't know that they are, which would be kind of unlikely, or they, for whatever reason, didn't want to tell us. But I think it's probably safe to assume that this is not happening at all, or very, very slightly. A third option would be to do some more education of our members around pension buyouts. We do it in our active member publications, in our retired member education, and our benefits counseling, all of that. Again, we run the risk of doing so, of some people, it might give them an idea they might not otherwise have had. So I think we need to be careful about that. We also need to be sure that we're absolutely objective about what we're saying, so we don't open ourselves up to some liability with respect to companies. So, but that's certainly an option that we could do within our existing authority. A fourth option would be to modify our forms so that when people are, so that there's some acknowledgement in the material that they sign, particularly when they open up a joint bank account. Because the way that these programs work is that you're receiving a pension and you enter in this arrangement. What happens is that you have a joint bank account with the company, and then your check goes into that bank account, and then they take the money out of that account. You are both owners, and so we wouldn't have any visibility of it. We don't know. We know who has a bank account. We don't know whether it's jointly owned or with who. So that would be, right now, that would be very difficult for us to determine whether or not they're entering into a relationship. But we could, in the course of somebody modifying their banking information with us for direct deposit, have a provision that acknowledges that these pension buyout arrangements are illegal and that they are unenforceable, so that at least there's something that we're putting out there that sort of gives them a heads up that you're not allowed to do this. We can continue to monitor our nationwide activity. As I said, we've worked with the U.S. Senate who's doing some investigations of this, and also working with the Attorney General. And then finally, we could review member bank accounts. This is like the most extreme approach is reviewing member bank accounts to try to identify jointly owned accounts where the co-owner may be a private company, which could be an indicator of such an arrangement. I mean, I think the thing that we need to be careful about is it appears likely that this is an extraordinarily unusual arrangement, if at all, and it would be a pretty intrusive thing for us to go in and try to second guess why somebody has a joint bank account and with who. There may be perfectly legitimate reasons why people have a joint bank account with a company that we wouldn't necessarily want to get into that. We would clearly need some additional authority to do that. So that's something that would be a pretty extreme approach. In terms of, so in summary, I think in terms of the three things that we've identified, which probably be most appropriate and least intrusive, is one is providing some additional education to our members around pension buyouts, acknowledging that we run the risk of giving people a heads up, of giving them an idea they might not otherwise have.
Maybe we should start by warning, exclamation,
Yeah,
exclamation,
that
in
could
red
be.
or something.
Really, if you're thinking of doing this, don't read any further.
Exactly.
Having them in their when they open up changing their direct deposit, they have to acknowledge that these arrangements are not allowed to assign their benefits, and then finally continuing to monitor the national activity that's going on around pension buyouts. But we would not suggest pursuing the ones that require some additional legislative authority, because we just don't think those would be effective, or it's a fairly extreme reaction to a problem which is probably relatively minor. So with that, I'd be happy to answer any questions.
So, any questions? Paul?
Yeah, I mean, I think, I agree with does not seem to be a need to do very much because it really hasn't been identified as a problem that a lot of members are taking advantage of this, or disadvantage of this, as the case may be. But I think it is instructive. I mean, I don't think it's that when we publicize the downsides of it, that we're putting ideas into people's heads. I'm sure these are people who really need money, and that sometimes is absolutely the case.
Right.
What's really wrong here is, as you were saying, that you know, the effective interest rate on these things is exorbitant. I mean, if it was 5% for people who really needed it, we probably wouldn't identify it as such a great problem.
Right.
So, I mean, I think monitoring national trends, if we start hearing complaints, but otherwise, it seems to me it's not not a problem that rises to a priority for us.
Anyone else? I totally agree with Paul.
No,
I
that's
mean,
fine. We just
I
wanted
think we
the
definitely need to
board
keep
wanted
our
us to-
finger on it.
Yep.
I don't want to lose, well, I guess if it raises its head and we have members starting to do it, then we would take action on it. But I think we need to keep it on the back burner and an idea, at least that the declaration perhaps, sometime in the future, that might be a tool that we could use also.
Okay, so in the meantime, we can just monitor trends and see what's going on.
Yeah, I
And if
think
something
so.
comes up, we'll let you know. We can go from there.
All right,
Okay.
anyone else? All right,
Thanks.
thanks. Jack, we come to you.
Just a couple things to highlight. Your offsite's coming up on October 17th and 18th, and just for the public's benefit, we've sensibly organized the agenda so that the first day is open session from 9 to 3, so there's not a lot of in and out disruption of the agenda. And we had sent you a draft before, and Dana hasn't altered anything, but we'll finalize it and get it publicly noticed. So that's all set. Relative to our 100-year celebration, Irina, you probably saw a few banners here and there as you walk in the building. We're one of the oldest pension systems in the country, actually, and so we've been
3 of them in the back of the room.
in the back of the room. Yeah, but we haven't said this number for a while. When our staff was organizing the receptions and just trying to reach out to those that are 100-year-old, our database indicated there are about 415 members that met that criteria. It, of course, goes up and down by the day, but it is an amazing number of individuals.
It's an amazing number.
A number of you, and this is the best part of the agenda because it's about our members. The reception we had here at the headquarters was really lovely. We had several 100-year-old retirees that came, and we just have about 2 minutes here to show you the highlights
Oh, good.
of the
Oh,
ceremony.
I would have had a video of me.
Yes, and it is a video, and it is a video of Dana. But it is wonderful, I think, to capture the emotion of the day. So just take a peek at this for a minute. Thank you.
I started in 1944, and my salary was $1,700 a year, and I retired in the year 2000 at the age of 76.
She was a spitfire. She was a spitfire.
I taught for 50 years. I actually taught all over Northern California. And I actually did some teacher preparation for 6 years and went out to small rural schools. There were a lot of one-room schools. There are still in Northern California.
I'm very grateful to have been in such a great state, a great system, and where I spent my career. It was a great trip, and it seems like it was just yesterday that I started up and ready.
I've been a teacher for 51 years. If your passion is to teach, pursue it. You'll love it, and your kids will love you for it.
You know, I know you've had a lot of fun today discussing technology management, but this is what it's
I like
about.
the photo frame.
This is really what it's about. I want to particularly single out Kathy Halstead, who was our project manager. Where are you, Kathy? For the event.
And we have 2 more celebrations
And
to
we
go.
have one next week in Glendale as well. But it really, you know, I think you could capture the sentiment from that video very well. And really, that takes me nicely to the last thing I wanted to mention during the staff meeting. Obviously, you saw a lot of our employees come in here at the end. They all work in our communications staff, and this is just one example. But those awards, those pages of awards that you see at the end of this report are competitive awards that are won through associations recognizing excellence in communications. And it is the lifeblood of this organization. It really is. I mean, no matter how well we design products and technology and all these things, if the members can't understand them and use them well, then we're not successful. So this staff works extremely hard under Krista Noonan's leadership to produce all this work you see day in, day out. You see their touches everywhere you go in this building, and on your materials, on your PowerPoints, on the newsletters, on the websites, on the Twitter feeds, on the Facebook pages, and it goes on and on. And, you know, 12 years ago, we had just like written publications primarily here in the organization. It's night and day. And so we all want to thank you very much, everyone. Did you want to say anything, Krista, or I don't know if you were? No, you were. Okay. All right. It is. It is. All right. Back to you. Okay.
Of course, I would cry. Hello, Jack. Alrighty. Consent agenda number 13. We did 12. Did we have a record from the appeals, Michelle, that we didn't get adopted into the record? I think I said that we'd add it. Yeah, we have that, so we'll take that and the investment committee. So I need a motion to adopt that. It's been moved. It's been seconded. All in favor say aye.
Aye.
All opposed nay. Any abstentions? Then that committee, those 2 committee reports are adopted. Items referred to the committee for board decision, we don't have any. New business, review information requests. We talked an awful lot during some of our reports about, particularly during the pension solution, about near-time milestones and having robust reporting with that. I think that was just all captured within us moving forward. But there was talk of perhaps doing some more educational things with Graham, with Grant Thornton. Did anybody out there catch that as something that the board might want to do? And did you capture anything else?
We want to find the right balance. We don't want to overload you every meeting with all
Right.
this technology, but we'll get the best fit for you. I don't want to. I think that's all we do.
Alrighty. Did you have anything else that you captured, Jennifer? Alrighty. Draft agenda is item number 16. Go ahead, Grant. Oh, I'm sorry, I didn't see you. There you go.
This may be covered just in the normal course of the work plans, but Tom had mentioned CEM data both on the investment and the pension administration side. I don't know if okay.
And you were going to get that to us, right, Jack? The past report?
Yes.
Okay, thank you, Grant.
Yes.
Alrighty, draft agenda. Everybody take a look at that. You can see that we'll have our financial statement review. from Robin. Ed will come back with the regs.
Finalization of the budget.
Okay. Any questions about it? Already,
So it's a little more concise meeting, I think, probably it looks like for November. That might be true for investments, as they've left on me. Investments as well, because we're not doing your performance reports and you've finished some of your larger work, so.
right,
Let's hope that it's not 1,000 pages for November.
right. And then Brian, I see that we're doing the annual ethics training. There's ethics training required by the state also, isn't there?
Every 2 years.
Every 2 years?
Every 2 years,
Can you
yeah.
make sure that we get an update of who all needs to do that?
Oh,
So we
yes.
can have that
You
done
will-
about that time
You will
too?
definitely hear from Tiffany. on
Alrighty,
that.
thank you. All right. Is there anyone from the public that would like to make a statement that hasn't done so yet? Alrighty, then we will adjourn the open session, come back into closed in 5 minutes.